Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss a new temporary restraining order issued by a federal court for violating people's constitutional rights, even the rights of native-born U.S. citizens. On July 11th, 2025, the U.S. District Court for the Central District of California issued a restraining order in which Judge Maem Iwusi Mensah Frimpong ordered the Trump administration to obey basic tenets of the U.S. Constitution, among other orders, after reviewing significant evidence. Judge Iwusi Mensah stated in her order, quote, "As required by the Fourth Amendment of the United States Constitution, defendants shall be enjoined from conducting detentive stops in this district unless the agent or officer has reasonable suspicion that the person to be stopped is within the United States in violation of U.S. immigration law. Defendants may not rely solely on factors below, alone or in combination, to form reasonable suspicion for a detentive stop. Apparent race or ethnicity, speaking Spanish or speaking English with an accent, presence at a particular location, example bus stop, car wash, tow yard, day laborer pickup site, agricultural site, etc., or the type of work one does. Defendants will maintain and provide documentation of detentive stops, including factors supporting reasonable suspicion, to plaintiff's counsel on a regular schedule. Defendants will develop guidance concerning how agents and officers should determine whether reasonable suspicion exists when conducting detentive stops. Defendants will implement associated training for defendants, agents, and officers involved in immigration operations in this district. The judge further ordered the Trump administration to provide access to counsel to individuals detained by ICE in the Los Angeles area due to issues I will describe next. The judge ordered, quote, "Defendants shall provide access to room B18 of the federal building located at 300 North Los Angeles Street, Los Angeles, California, 90012 for legal visitation by current and prospective attorneys, legal representatives, and legal assistants. Legal visitation shall be permitted 7 days per week for a minimum of 8 hours per day on business days, Mondays through Friday, and a minimum of 4 hours per day on weekends and holidays. Defendants shall provide individuals detained at B18, B18 with access to confidential telephone calls with attorneys, legal representatives, and legal assistants at no charge to the detainee. Such legal telephone calls shall not be screened, recorded, or otherwise monitored." Folks, I never thought that I would see a federal court ruling like this that was issued during my lifetime when I was learning constitutional law as a second-year law student. Yet, here we are in one of the most significant fights for American civil rights and liberties in U.S. history today in the 21st century, year 2025, and nearly half the country is still in a hyper-partisan, politically intoxicated stupor. Wake up. While things are bad, they can still get much worse. And we can still win this fight. Stay positive and keep speaking truth to power, and make lawful constituent communications to your representatives in Congress. Put the fear of losing their next elections in them if they don't start conducting oversight over the Trump administration and utilize their congressional leverage. The public needs to legally pressure Congress to exercise oversight and impeachment with removal. I don't see how this self-destruction by felons and grifters is suitable. The public needs to legally pressure Congress for impeachment and removal. The public should then legally pressure the next president to allow the U.S. Department of Justice to investigate and follow the evidence, the facts, and the law, and prosecute President Trump and any other government officials and other co-conspirators of any and all criminal activity that they may have knowingly participated in during this Trump administration in accordance with the U.S. Constitution and U.S. law. The U.S. Supreme Court ruled a year ago in its July 1st, 2024 decision in Trump versus United States that private conduct that falls outside the outer parameters of the office are not protected by presidential immunity. Back to the California case. The judge stated, in part, in her order, quote, on June 6, 2025, federal law enforcement arrived in Los Angeles to participate in what federal officials have described as the largest mass deportation operation in history. The individuals and organizations who have brought this lawsuit argue that this operation had two key features, both of which are unconstitutional. Roving patrols, indiscriminately rounding up numerous individuals without reasonable suspicion, and having done so, denying these individuals access to lawyers who could help them navigate the legal process they found themselves in. On this, the federal government agrees. Roving patrols without reasonable suspicion violate the Fourth Amendment to the Constitution, and denying access to lawyers violates the Fifth Amendment to the Constitution. What the federal government would have this court believe, in the face of a mountain of evidence presented in this case, is that none of this is actually happening. On June 6, 2025, federal agents detained multiple day laborers outside of the Westlake Home Depot. In the following days, similar raids occurred throughout the district. Car wash workers, farm and agricultural workers, street vendors, recycling center workers, tow yard workers, and packing house workers were targeted. In one instance, the agents approached and prevented a non-white individual from walking away, but not those who appeared to be Caucasians. In another, the agents arrived in unmarked vehicles, pointed a gun, and demanded to see identification without providing a reason for the stop. Yet, in a different context, the agents provided no reason for stopping individuals at a church. Since they began on June 6, 2025, federal immigration raids have led to the arrest of over 1,500 people. Agents and officers approach suddenly and in large numbers in military style or SWAT clothing, heavily armed with weapons displayed, masked, and with their vests displaying a generic police patch. Agents typically position themselves around individuals, aggressively engage them, and/or shout commands, making it nearly impossible for individuals to decline to answer their questions. When individuals have tried to avoid an encounter with agents and officers, they have been followed and pushed to the ground, sometimes even beaten, and then taken away. These incidents have been widely reported in the news. Defendants have a policy and practice of effectuating warrantless arrests without making an individualized flight risk determination. Defendants also have a policy and practice of not identifying themselves or explaining the basis for an arrest upon taking someone into custody. Agents and officers often show up masked, without any visible badges or insignia indicating what agency they work for, and have refused to identify themselves when asked. Next, the judge addressed the confinement conditions. During the ongoing raids, and as an integral part of the policy and pattern of unlawful stops and arrests, defendants have been taking individuals who are swept up to the basement of the federal building at 300 North Los Angeles Street in Los Angeles, commonly referred to as B18, B18. B18 is a facility for immigrant detainees designed to hold a limited number of individuals temporarily so they can be processed and released, or processed and transported to a long-term detention facility. It does not have beds, showers, or medical facilities. Individuals taken to B18 are being kept in small, windowless rooms with dozens or more other detainees in cramped quarters. Some rooms are so cramped that detainees cannot sit, let alone lie down, for hours at a time. As of June 20th, 2025, over 300 individuals were being held at B18. Detainees are also routinely deprived of food, and some have not even been given water other than what comes out of the combined sink and toilet in the group detention room. Upon asking for food, detainees have been told repeatedly that the facility has run out. Detainees are denied access to necessary medical care and medications. Individuals with conditions that require consistent medications and treatment are not given any medical attention, even when that information is brought to the attention of the officers on duty. On June 19, 2025, an immigration defense attorney arrived at B18 to meet with detainees, including one who was scheduled for a chemotherapy appointment the next day. Despite showing a doctor's note confirming the appointment and specifying that missing the appointment would be detrimental to the detainee's health, the guards repeatedly would not allow the attorney to meet with the ill detainee. The facility cannot provide detainees with basic hygiene. Individuals who are menstruating have had to wait long periods before receiving menstrual pads, if they receive them at all. Next, the judge addressed limited access to counsel to B18 detainees. Quote, individuals detained at B18 have had their access to prospective or retained counsel restricted. On June 6, 2025, attorneys and legal representatives attempted to gain access to B18 to advise detainees of their rights and assess their eligibility for relief, but they were not permitted to enter. When they returned to B18 the next morning, attorneys identified a handwritten notice on the door of the family and attorney entrance at B18 indicating that B18 would not permit any visits that day. Federal officers then deployed an unknown chemical agent against family members, attorneys, and representatives. The chemical agent caused everyone to cough and inflicted a burning sensation in the eyes, nose, and throat. The same morning, numerous unmarked white vans quickly departed B18 with a group of detainees. Attorneys and representatives attempted to loudly share Know Your Rights information with the detainees in the vans. Federal agents blasted their horns. On the rare occasions when attorneys and family members were allowed access to their clients or loved ones, they were made to wait for hours at a time to see them, and the resulting visits were limited to a mere 5 to 10 minutes. In many cases, attorneys and family members were unable to determine whether a particular individual is even detained at B18 or whether they had been transferred to another facility. Officers have refused to provide clear answers to questions about detainees' whereabouts or refused to answer questions altogether. ICE's online locator, which provides information about detainees' location, is not updated in a timely manner. Next, the judge addressed Trump administration sanctioned conduct. Quote, in January, the administration gave ICE field offices an arrest quota of 75 arrests a day. The administration also shut down multiple oversight agencies. The administration set a new arrest quota of 3,000 arrests per day and reportedly threatened job consequences if officials failed to meet arrest quotas. Next, the judge shared numerous accounts provided by plaintiffs in the lawsuit, including the following. Quote, in the afternoon of June 12, 2025, a U.S. citizen was at a tow yard in Los Angeles County that was visited by immigration agents conducting a roving patrol. Around 4:30 p.m., upon hearing someone say that immigration agents may be at the premises, the individual went outside to confirm this. At the time, his clothes were dirty from working on his car. On the sidewalk outside the gate, the individual saw a federal agent between two cars step forward. Soon after, he saw several other agents wearing similar vests with the words, Border Patrol Federal Agent. He also noticed that the agents were carrying handguns, and at least two of the agents had military-style rifles. When he attempted to head back inside the tow yard premises, a masked agent said, "Stop right there." While the agent approached him, another unmasked agent ran toward him and asked if he was American. He told the agent that he is American multiple times. The agent responded by asking, "What hospital were you born in?" He calmly replied that he did not know. The agent repeated the same question 2 more times, and each time he provided the same answer. At that point, the agents pushed him up against the metal gated fence, put his hands behind his back, and twisted his arm. He had been on his phone, and the masked agent also took his phone from his hand at that point. He asked that the agents, he explained to the agents that they were hurting him and that he was American. The unmasked agent asked the final time, "What hospital were you born in?" He responded again that he did not know and said East LA. He then told the agents that he could show them his real ID. The agents had not asked to see his ID. When he showed his real ID to the agents, one of them took it from him. It ultimately took about 20 minutes for him to get his phone back, but the agents never returned his real ID. Unsurprisingly, the Trump administration has appealed the court's order to abide by basic American constitutional law. Immediately contact an attorney as soon as possible if you believe your rights have been violated by a government official. If a state or local official violates your constitutional rights, you may have a claim where you could recover damages under 42 United States Code 1983, titled Civil Action for Deprivation of Rights. If a federal official violates your constitutional rights, you may have a claim where you could recover damages, which is called a Bivens claim under the 1973 U.S. Supreme Court precedent from a case named Bivens versus 6 unknown agents. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.